Welcome to Fighting Bullies with Bill Reid.
Welcome to Fighting Bullies with Bill Reid. Bill is the senior founding partner of Reid Collins and the author of Fighting Bullies, where he challenges what law students and young lawyers are told about prestige, career paths, and success in the legal profession. Drawing on decades of experience trying high stakes cases, Bill makes the case for a different path. I'm Lisa Mosby, and on today's episode, we're talking why plaintiffs' lawyers, not corporate defense lawyers, are often the real heroes. Bill, in your book, you argue that most of the legal heroes people admire, say in films, literature, and real life, share something in common. What is it?
Well, I think they're either plaintiffs' lawyers or criminal defense lawyers. They very rarely, if ever, are prosecutors, and they are virtually never, if ever, a civil defense lawyer. In other words, a big firm lawyer.
And there's a cultural image of the powerful corporate lawyer as the pinnacle of success. How does that differ from the kind of lawyer who actually drives social change?
Look at it this way. If you're defending corporate America, and look, there are frivolous cases every day, so let's just break it into categories. You might use your legal talent to get rid of, call it frivolous or weak cases, and have them dismissed, or have a good result for your client in terms of paying no money and making a fee for yourself. Nothing, that's honorable, nothing wrong with that. But let's just assume now there's a whole other basket of cases that are viable, or at least there's a credible allegation that the corporation has done something wrong. And then the question is, what is the price tag that that corporation should pay for what they did? Or could be any entity, doesn't have to be a corporation, could be any business actor. Well, you could see how representing those sorts of people is not really affecting societal change. It's not, you're not really making a difference. You're just protecting the big and the most powerful from the true consequences of their actions. That doesn't make any difference. Might make a nice living for the corner office partner in big law. Now, in contrast, let's look at the plaintiff's lawyers who bring that category, that same category of cases. Now, the plaintiff's lawyers who bring the lousy cases, they shouldn't bring those cases in the beginning. And as between them and the defense lawyers, I'd rather be the defense lawyer, but I choose to be neither of them. But as to the viable claims, in which business actors, which is what I do bad or wrong things, doesn't necessarily be like intentional. It could just be stupid. They made a mistake and caused a consequence. Well, in those valid cases, which side would you rather be on? Where do you think you could make more difference? Representing a plaintiff who's actually harmed by bad or wrongful conduct? Or would you rather represent the people that engaged in the wrongful conduct? These are just basic questions of what would you rather do? And I think you can begin to see how you can at least begin to think about making a difference on the plaintiff side. Whereas on the defense side, you're not really making a difference. Or at least that's my view.
And you discuss historic examples like the Ford Pinto case. What does that case reveal about the role plaintiffs' lawyers play in protecting the public?
Well, look, you could think of, I put a number of examples in my book. If it weren't for plaintiffs' lawyers, the Pinto probably would have killed and maimed a lot more people than it did. If it weren't for plaintiffs' lawyers, we would have asbestos in a lot of, like, as I put in my book, the government actually never was successful in banning asbestos. It was only the cost of the litigation consequences of the conduct of asbestos manufacturers that led the manufacturers themselves to abandon the production of asbestos. The list goes on of all of these things that plaintiffs' lawyers have done over time that make us all safer, which is why plaintiffs' lawyers are occasionally referred to as citizens general. In other words, we don't have a government big enough to handle all of the wrongdoing that occurs in our society. And the people that fill that gap and protect all of us are plaintiffs' lawyers. Now, can I tell you that every plaintiff's lawyer is lily white and doing the right thing? I'm not suggesting that. I'm just saying if we're looking at who is actually making a difference, that is actually plaintiffs' lawyers, time and again.
And in your own practice, you've taken on major financial institutions. Can you share an example of a case that illustrates what it really means to fight a powerful opponent?
Well, I do it every day, but probably the longest running case is my Credit Suisse case, where I fought for 10 years with the big Swiss bank over whether or not they committed fraud. And, you know, uh, I mean, it's like unraveling the most complicated puzzle that you've ever had in your life. And so I love the practice of law when it comes to solving legal puzzles. And, a lot of areas of the law don't allow you to do that. But in complex commercial litigation, which is my area, you can imagine where today's business world crosses international borders and many state borders. And we have a state and a federal system. And all of the law that potentially applies to a transaction can be used to right a wrong. And so that kind of complex web is really fun to navigate if in the end you can hold a wrongdoer accountable. So in the case against Credit Suisse, they arranged for an appraisal of land in Las Vegas. That the appraisal said the land was worth 517 to 891 million dollars. On that basis, my client lent hundreds of millions of dollars along with other people, and the property was sold in bankruptcy a few years later for $17 million. So to say that it was a slight fraud is an understatement.
And why is it that plaintiffs' firms are often willing to take the risks that larger institutional firms avoid?
Well, the decision that larger firms make is a business decision. They choose to represent corporate interests, and in doing so, they then acquire conflicts of interest. So, the best example of this is the 2008 financial crisis. Prior to 2008, everyone wanted to represent banks. Banks were great clients. They have lots of money, they pay their bills regularly, and they get sued a lot. Great to defend banks. In 2008, when everyone began to realize, hey, wait a minute, all of this wrongdoing that nearly destroyed our economy was done by those same big banks. So we'd like to sue them. And by the way, the people that sued them made a lot of money. But the big firms that had already chosen to defend those banks had conflicts of interest. They couldn't just turn around and sue their current clients. They were unable to do that. And so that gave rise to a whole wave of law firms that didn't have those conflicts of interest and were able to pursue those banks. It's just a real world recent example of the decisions that big firms frequently make, and that then forecloses their ability to change course in the future.
I don't know how to ask this question, so I'm just going to throw it out there, Bill. But there is a perception that plaintiff's law is less prestigious or maybe less sophisticated than defense side work. Where does that perception come from, and how accurate is it?
Well, the perception that plaintiffs' lawyers are ambulance chasers and that plaintiffs' work is out of hand and litigation is bad, I think comes from a number of sources. First source would be the tort reformists, which I call my book propaganda, which is what it is. It's not some sort of scholarly research. And it normally arises from the false characterization of prior plaintiffs' cases. The most famous one is the McDonald's coffee cup case, which everyone loves to tout about as an example of the plaintiffs, bar running amok and runaway juries and whatever other nonsense these propagandists espouse. But the facts of the McDonald case, as I lay them out in my book, tell a very different story than the one that the tort reformists would like you to believe, which at the end of the day is McDonald's knew it was selling super hot coffee. It lied about the reasons that it was selling super hot coffee. A decade goes by of like numerous injuries, and this poor little old lady spills a coffee cup or a cup of coffee 190 degrees in her crotch. 2 years later, after 7 skin grafts and countless surgeries and all kinds of pain and suffering, McDonald's was forced to pay. I think 2.7 million was the ultimate jury verdict, which was determined based on just 2 days of coffee sales of McDonald's, multiplied by three for exemplary damages. And meanwhile, the judge wrote the damages down to a lower number, which the judge was permitted to do. And so the justice system actually worked, and McDonald's should have been held accountable. Now, Is this a sophisticated piece of litigation? No, but the point of it is the characterization of it is wrong. And you hear every day about how juries are running amok and doing all these crazy things. Well, let me give you a fact. In 1960, 20% of all civil cases filed in federal court went to trial. 1 in 5 cases. You know what that number is today? Less than 0.5%. Less than 1 in 200 cases go to trial. So the notion that we have runaway juries and that juries are getting it wrong and that juries should be feared, in spite of the fact that it is the most frequently mentioned right in the U.S. Constitution. The right to a jury trial is mentioned like 7 times. The bottom line is it's a core right that we all have. And like the vilification of the jury trial and plaintiffs' lawyers by the tort reformists is, I think, reprehensible. But it doesn't start or end there. I think law schools actually perpetuate that notion. And as I've mentioned before, I do think that the kind of let's just say the short end of the plaintiff's bar, the people doing all the things they shouldn't be doing, and the ambulance chasers, the people that deserve all the stereotypes, they give plaintiffs' lawyers a bad name. They do. That doesn't mean that all personal injury lawyers are bad. It doesn't mean that all plaintiffs' lawyers are personal injury lawyers. None of those are true. But there are enough bad ones out there whose sole mission in life is to get the next client, regardless of whether or not they have the ability to do the underlying work or the willingness, is a problem. And so there's problems all the way around. And as a result, I think these young law students are left with a lot of misapprehension and a lot of misimpressions about what really it means to be a plaintiff's lawyer.
Well said. I want to give you a standing ovation because yes, I'm with you 100% on that. You know, you argue that plaintiffs' lawyers often create structural change, not just individual wins. How does that ripple effect work in practice?
Well, I think it starts with a lawyer who takes up whatever the cause is, and normally it's preceded by a number of losses. Like, think about this. I'm reading a book now, and the initial wave of suits against the tobacco companies were brought by smokers. And so the lawyers that brought those cases pretty soon realized that that was not the ideal plaintiff. In other words, that juries couldn't get over the issue of this person chose to smoke. And yeah, the cigarette companies probably lied and manipulated the nicotine levels to cause people to really need to more and more cigarettes or whatever the story is. But at the end of the day, the ideal plaintiff was not the smoker. And some genius plaintiff's lawyer, after losing his shirt a number of times, trying these cases, pushing the boulder uphill, had a eureka moment and said, wait a minute, these state Medicare agencies are paying out massive healthcare bills for the smokers that they insure. They're suffering a loss and they didn't make that decision. And they actually have huge losses. They're an amazing plaintiff. And so once that idea was, essentially this eureka moment idea was unleashed, then everybody filed suit. And within a period of a year or two, every state attorney general in the country, from red and blue state alike, filed suit, and massive multi-hundred-billion-dollar awards were essentially agreed to in the end. And the truth came out that the tobacco companies did, oh boy, surprise, surprise, really bad stuff along the way, and they were held accountable. But when you say, how does change occur? It normally occurs by someone encountering a wrong, in this case, smoking, and then going about it in a way that doesn't necessarily succeed at first, but eventually the law enables you to get it right. And I think the tobacco example is a great one. There's many others. A lot of them are in mass tort and personal injury or product liability type cases. I'm pretty sure the first Pinto case was not necessarily a bonanza, but as I put in my book, Ralph Nader created NHTSA, the National Highway and Traffic and Safety Administration, and then that required the car manufacturers to file these reports. And the morons at Ford put all of the information in their NHTSA report that the plaintiffs ended up using in proving that they had made a calculated choice of valuing a human life at like $170,000, which we all know how that turned out for Ford. not great. So anyway.
Financially, plaintiff's law is often misunderstood. How does the economic model differ from the billable hour structure that we discussed earlier?
So when a lawyer is charging an hourly fee and doesn't really care in an economic sense or really in any sense about the outcome, you can see how there isn't a great alignment between the lawyer and the client's interest. Now, I'm sure that there's a lot of really sophisticated hourly fee lawyers who would say, yeah, that's ridiculous. We clearly care about the results. Otherwise, we can't build careers and success and be Cravath or whatever fancy firm you want to come up with. Okay, I'm not denying that's true, but there is no alignment on the economics. Winning the case, in fact, winning the case early ends the right to the future fees. So the lawyer actually suffers economically the sooner the lawyer wins as a defense lawyer charging an hourly fee. In contrast, if a success fee lawyer succeeds, what happens? Well, the success fee lawyer, of course, makes a fee, and so does the success fee lawyer's client. So, in that sense, there is a complete unity of interest in terms of the ultimate goal. Both the client and the lawyer desire the greatest economic success possible because they share in the result. There's a much closer partnership when it comes to the economics. Now, there are lawyers that do all sorts of bad stuff and cheat their clients and con them into taking settlements they shouldn't take because they're lazy and don't want to do more work. All of that happens. So I'm not saying in each and every instance in which there's a success fee, the lawyer behaves honorably, the lawyer and the client are totally not saying that. I'm just saying it's a much better alignment than the hourly fee. That's all I'm saying.
I'm following you. For someone who's listening who feels drawn to impact-driven work but worries about the long-term stability, what should they understand about the future of plaintiff firms? And that's where we'll wrap it up today.
Well, a great lawyer whose book I read recently said, fortunately, human greed is not going away. So the assumption that human greed will continue, I think, is a safe one. And as long as there is human greed and people willing to cut corners and do bad things so they can make more money and whatever the consequence is, have a less safe product or somebody gets cheated when they should in a business transaction or whatever, all that's motivated by greed and that's not going away. So what does that mean? There's going to be continuing need for plaintiffs' lawyers from now forward.
I agree. And, I really appreciate your insights today, powerful insights today. Thank you so much for creating a lot of clarity and sharing some great cases to drive your point home. Folks, that's it for today's episode of Fighting Bullies. If you're a law student or early career lawyer trying to make smarter decisions about your path, you can learn more about Bill's book at fightingbullies.com. Thank you so much for listening. And don't forget to like, subscribe, and leave a review. Join us next time as we continue exploring what a meaningful and sustainable legal career can look like. We'll see you then.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.